under OCGA 1791. The defense maintains that the state has failed to present evidence upon which a rational trier of fact could find guilt on any of these counts. I'll go through each of them one by one. Regarding, well, let's take the malice murder and the felony murder together, Your Honor. The only evidence that the state has presented that in any way ties my client to the murder of Mindy Kassotis is my client's vehicle being seen near the scene of the body where Mindy Kassotis was found. They have also presented evidence of my client's cell phone being in that general area, as well as some of Mrs. Kassotis' blood being found at their marital residence. The other evidence presented with regard to, for example, the knife being found at the scene of the body, the tool mark expert got on that stand and testified that that knife could not have been used to dismember Ms. Kassotis. Regarding the Bass Pro Shop knives, which have not even been found, that particular knife was neither ruled in nor ruled out. They have not shown a murder weapon. They don't have any idea of the location of the murder. They're not witnesses. My client's DNA is not found at the scene of her body. There's no fingerprint evidence. So I do not believe that a rational trier of fact, viewing all of that evidence, could find that Mr. Kassotis murdered Mindy Kassotis, neither felony murder nor malice murder. As far as count 3, aggravated assault, again, similar to that, there has not been evidence that my client assaulted Mrs. Kassotis other than that described above with respect to the 2 murder charges. Concealing the death of another, the state has done extensive investigations. Agent Sands relentlessly had his team look for evidence of concealing the death of Mindy Kassotis by Mr. Kassotis. They didn't find tools that were used to dismember her. They did not find evidence of her dismemberment at the house other than some of her blood being on the futon, and that was not a great amount. They did not find power tools that could have been used to cut up the body, like some of those false starts would indicate were used. So the only thing they have is his car being near the scene of where her body was found. Count 5 is the possession of a knife during the commission of a felony. They have Mr. Kassotis buying a knife similar to a knife that was found at the scene, but they have not shown his possession of that knife during the commission of any felony. The next set of counts all relate to possession of tools for the commission of a crime. Again, they have that one knife that was not used could not have been used, according to the tool mark expert, to dismember her. They have the Bass Pro Shop knives, which could neither be ruled in nor out. The removal of body parts from the scene of a death, count 11. They have no idea. The state has presented no evidence of where she died. They do not know where the scene of the death is. So there's just no evidence that body parts were removed from that scene of the death, especially because they can't even place the scene of the death. And count 12, tampering with evidence. Again, there's not been evidence that my client destroyed or concealed or used tools with respect to tampering with evidence. So what we have from the state is obviously a lot of circumstantial evidence. I fully appreciate that the jury can render verdicts on circumstantial evidence, but I would maintain that circumstantial evidence is insufficient for a rational trier of fact to find that Mr. Kassotis committed any of these counts 1 through 12. Thank you, Your Honor.
Thank you.
Ma'am?
Yes, ma'am.
Your Honor, I'll start at the beginning as well with malice murder. We've talked at varying points during the course of this trial leading up to today about the issue of venue, and it has been very clear that the legislature for the state of Georgia has made it very abundantly clear that they did not intend to allow murderers to essentially go free because they then subsequently moved a body or tampered with the evidence concerning the scene of a crime. With respect to the malice murder, Your Honor, it is abundantly clear from the evidence presented by the state that Mr. Kassotis, and in his own statements, was involved in a bloodletting event that was in the house in Savannah, Georgia. That incident, unfortunately, controlled by Mr. Kassotis, ultimately puts the state in the position of not being able to know exactly where she was killed, which is exactly why the venue statute permits in murder cases for it to be where the body is discovered. Her body somehow got from Savannah, Georgia to the woods in Riceboro. And I would point out that when it got to the woods in Riceboro and the autopsy was conducted, there were 9 traumatic injuries to her skull. She did not do those to herself. The only person that had access to her was Mr. Kassotis. That's the state's position, Your Honor, and that's the evidence that the jury will consider and have to render a decision as to whether or not they believe that presentation. In addition, Your Honor, there were defensive wounds, which indicated that she herself received those wounds from somebody else while she was alive. That would be the concern that the state has. The problem, Your Honor, of course, as counsel points out, is we don't know when she took her last breath. She could have taken that at any stage along the way. And as a result, the murder, Your Honor, the state's argument is this is not a snap murder. This is a premeditated, planned event. There is plenty of evidence before this jury that Mr. Kassotis went to extreme measures to purchase latex gloves, to purchase Clorox wipes, to purchase the knife on the very day that he then dumps her body. There's evidence that he himself transported those totes with him. He admitted that in an audio statement post-Miranda, and there is no dispute that they were a black and gray tote, which is what is sitting as I look at them in this courtroom. Mr. Kassotis then has the issue, and while I'm not required to prove premeditation, I'm also not required to prove a murder weapon. And the reason for the legislation in that, Your Honor, is clear as well. Defendants can take a murder weapon from a crime scene. That doesn't mean it didn't happen. So it's the state's position that there is plenty of evidence that Mrs. Kassotis was the victim of a violent assault, which also goes to the issue of felony murder. That issue being her being struck 9 times in the skull. In addition, we don't know specifically if any of those wounds were post or ante-mortem, the 3 at the abdomen. Those are additional assaults that just as easily could have been occurring within the county of Liberty during her dropping off in Riceboro. So it's the state's position that aggravated assault as the basis for the underlying felony murder is also present, Your Honor. That's a question of fact for the jury. The next count, Your Honor, that the state would discuss is concealing the death of another. And in this case, the way the state had articulated in the indictment was that he killed by dismembering her, transporting her body, and hiding it in a wooded area. It's the state's position that there is absolutely no question that that ultimately is what occurred in this case, and that's a question, again, for the trier of fact, that being the jury. The standard for the directed verdict is not beyond a reasonable doubt, and as a result, the state is of the opinion, Your Honor, that all of that evidence would be questions of fact for them. That said, the next series of counts, Your Honor, well, before I get there, is knife and commission. We know that Mr. Kassotis purchased the knife that we described on November 29th of 2022. That is the date articulated. He clearly possessed it. The state's position would be it was underneath his arm. There was a receipt showing he purchased it. And at that time, it's the state's argument that he purchased that knife in anticipation of needing to cut, unfortunately, I have to be this graphic, but the flesh of Mrs. Kassotis. The tool mark expert indicated that no, it was not used on the bones, or at least she couldn't say for sure because they were shallow cuts. But what she did say was she can't say for sure that it wasn't used on the neck or the other portions of her remains, unfortunately, to gain access to her bones. That said, it's the state's position that that also should be a question of fact for the jury. The possession of tools for the commission of the crime, I would just point out, Your Honor, I have those listed in counts 6 through 10, and those specifically articulate each of the tools that the state alleges that the defendant used, and that was in anticipation of the crime of commission of removal of body parts from scene of death or dismemberment. I would like to point out that Mr. Kassotis was in the area of the Portal Hunting Club, it's the state's position, for 2+ hours. That is the time period that is referred to when he admittedly says he turned off his phone. And then he's there for 2 hours. And her torso, with her arms attached, her head, and her 2 legs were found in that area. It is entirely possible that Mr. Kassotis spent that entire 2 hours dismembering her and tossing her remains in exactly that area. There was not evidence that there was a dismemberment at the house, and given the information that Mr. Frank Mevin was in the residence at the time on November 29th of 2022, it is highly unlikely that Mr. Kassotis pulled out a power tool and was severing his daughter's limbs while he sat in the room. So it's the state's position he did that in our county, and that's up to the jury to decide, Your Honor. That also references the knives, the deer processing kit, the tubs in question, the Ford Explorer itself. It also references the shovel that he used to bury her head. We introduced evidence of the dig marks, and specifically on the roots. And additionally, Your Honor, that knife, although counsel indicates that his client purchased that knife and it was not used in this, that's a question for the jury to determine, Your Honor. And finally, the last 2 counts, one is removal of body parts from scene of death. Clearly, she was moved around. So it's the state's position, Your Honor, that she ultimately took her last breath and he then discarded her remains in different places. And finally, the last portion would be tampering with evidence, and the way that it is articulated in the indictment is very specific, with intent to prevent and obstruct the apprehension of prosecution of Nicholas James Kassotis by destroying biological evidence. and concealing tools from the commission of the crime. He bought gloves, he cleaned off the knife, he cleaned out the totes, there was cleaning wipes found at the scene, and it's the state's position that that's something that the jury needs to determine if they believe the state's position that that's exactly what he did at the scene of the crime. And as a result, Your Honor, I believe that each and every one of these counts should go to the jury for them to make the factual determination that counsel is now asking to be made.
All right, counsel, I do have concerns about a couple of counts. Now, counts 7, 8, 9, and 10 all allege possession of tools for the commission of a crime. And I've done some research, and of course,
What
all
crime?
of the cases, I looked at over 10 cases
He's gonna say
regarding the
flawed
sufficiency of evidence with that particular charge. And they all relate to burglary cases, entering automobile cases, but in every case, the tools were found in the defendant's truck, in the front seat, in the back of the vehicle. And there was a nexus between the possession of those tools and the crime itself. In this case, for example, count 7, the deer processing kit. I believe the evidence was that was purchased sometime before they found the torso down near the hunting lodge. So what is the nexus between the possession of those tools and the commission of the crime?
November 28th, Your Honor, was the date that the deer processing kit was purchased of 2022. November 29th of 2022 is when the defendant's vehicle is captured going specifically to Riceboro to put that body, is our position, in the woods. On November 28th of 2022, Mr. Kassotis' statement to law enforcement was he purchased the knife, meaning the Milwaukee knife. He references nothing about mosquitoes for the deer processing kit. It is the state's position, Your Honor, that that knife set was
I'm
purchased.
talking about the knife. I'm talking about
the
the
set,
deer- okay,
correct.
the whole set.
The set was purchased in anticipation of dismembering her remains, and that he then took her remains the very next day. He was not a hunter. There was testimony of that. He was not somebody that was known to hunt or have need for a deer processing kit, other than it's the state's position that he purchased it the day before he took her dismembered remains into the woods in Liberty County, and then those were distributed down there. There is no evidence, Your Honor, that the deer processing kit was used inside of the residence, because there is not dismemberment evidence at the house, but rather in the woods. So it's the state's position, Your Honor, that the jury would then simply have to determine if they believe, based on the fact that he made the purchase close in time to her actual dismemberment and distribution, was that used?
Same question with regard to count 10 and the shovel.
Your Honor, so in this case specifically, the only item that was adequately buried was her head. There was testimony from Detective Frost specifically that there was a place very close to where the head was recovered, buried underneath the ground, in the middle of, or I should say the very end of November, some cut marks into roots that appeared to have been from an object striking the root. And those photographs were introduced into evidence. I submit to the court that it's the state's position that he didn't dig with his hands to get her head into the ground. He had to use a shovel, which is why I introduced evidence of the November 4th, 2022 purchase of the shovel and the hammer that were present at that purchase from Home Depot. Ultimately, he is captured on the surveillance camera with the shovel in his hand, walking out of the store with it. And that was on November 4th of 2022. Those purchases for the wipes, Your Honor, I would submit go back to August 16th of 2022. So the premeditation that the state will argue, Your Honor, includes the latex gloves, the Clorox wipes, the actual shovel itself, the deer processing kit, the Milwaukee knife. He utilized the tubs, her blood was in it. So it's the state's position, Your Honor, that all of these were the tools that allowed him to commit the crime that we have before us.
Does the defense wish to weigh in?
Only to rely on the court's research that there's no nexus between these tools, no physical nexus at least, between these tools, these items that he purchased, the shovel a month before, roughly a month before she's found, the deer processing kit. Yes, he purchased the deer processing kit, but there's nothing showing that he possessed that at the time of the commission, alleged commission of this crime.
Yeah, I do have some concerns about counts 7 and 10, but with regard to all of the other counts, defense counsel has correctly pointed out, basically referring to OCGA section 24-14-9, that to authorize a conviction on circumstantial evidence, which is this case, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. In that regard, the court believes there is an abundance of evidence that points to the guilt of the defendant, albeit circumstantial. But that creates a jury question, and the court's going to submit it to the jury, and I will deny the motion for directed verdict as to all of those counts. Again, I have concerns about counts 7 and 10. But I'll also deny your motion with regard to those counts, and we'll submit it to the jury. All right, before we bring the jury back in, Mr. Weinstein, has your client made a decision as to whether or not he will testify this morning?
He has made a decision, Your Honor. My client wishes to testify.
All right.
What? Did
Do
he
you mind if I make an inquiry of him?
Did he say waive?
I would appreciate you doing that, Your
or
Honor.
take
Okay.
the stand?
All right. Sir, I've just been informed by your counsel that you intend to testify today. I
He
do
said he's
need to advise
testifying.
you that under the Fifth Amendment to the U.S. Constitution and also the Georgia
What?
Constitution, that you have a right against self-incrimination. That is, you have a right to remain silent. Do you understand that right?
Yes, sir.
All right. And are you willing to give up that right and take the stand and testify under oath?
Yes, I am, Your Honor.
And you understand that once you testify, you will be subject to a full, thorough, and sifting cross-examination consistent with Georgia law.
Yes, Your Honor.
Have you had sufficient